Welcome, good afternoon. I'm Martin Kretschmer, I'm the director of the Cleary Center, and we have the air conditioning on today, on the left and on the right, and this room is well known for being extremely hot, so we speak.
It's only going to get hotter.
Yeah. So we speak with open doors today, and we have a legend of our field here, Professor Paul Hield, from the University of Illinois, but also from Kuwait. He has been a fellow and a partner for a very long time. And as Chris Erickson, in his introduction yesterday, and also in the introduction to the students last week, indicated, you have been inspiration to the approach which Kuwait has developed over the years. That research in law is more than looking at words. It also means looking at the world and trying to understand what is happening as a result, as a condition for behavior. And Paul has written many papers which are cited everywhere. From research on copyright in the public domain, to trademark dilution, to transaction costs in patent law, the whole range of intellectual property rights he has studied, and he's now an emeritus, which nobody believes who knows him, but he also gave us an opening to appoint him as an honorary professor at the University of Glasgow, so I assume this is also, an inaugural lecture. we haven't really discussed this, but since it came through only last month, I think it's probably, we should acknowledge that. So, Paul, you have our undivided attention, apart from the instruction of the air conditioning, for 40 minutes, the max. You can do a bit less if you feel like it, and then we have good time for questions. Paul Hield.
Well, thank you, Martin, and thank you all for coming today. 40 minutes. If I was just going to speak from beginning to end, I think 40 minutes would be perfect. Since I've got about 6 or 7 different research projects I'm going to describe, I think I'll ask for questions after each one, so that you'll be able to keep in your mind easier what questions you have. It might work better that way. So, my total airtime hopefully is 40 minutes, but it might be spread out over longer than that. So this is something new. Normally I come to Glasgow and I've got a fabulous new research project that I want to present and convince the world is incredibly important and a must-read for anybody in the field. But as Martin mentioned, I've retired, and my research agenda is it's not moribund, but I don't have anything currently finished enough to present. So what I thought I would do is look sort of backwards over the last year to see what empirical work has been posted on SSRN, and sort of cherry pick some of the more interesting papers that I found. So SSRN is basically where most people, especially economists and lawyers, will post their work, and there's a subcategory which is empirical legal studies, intellectual property. So that's what I looked at. And I thought it was interesting to note the growth in empirical research over time. So there's 1,500 papers there under that category. 1,300 of them were posted after 2010. So just in the last 14 years. And you can break down, there's only 50 for the 10-year period, 96 to 2005, then 50 more in the next 2 years, 50 more in the next 2 years, 50 more in the next year. That's the 200 that's missing, not missing, that is not counted in the 1,300, and virtually everything else afterwards. There's a little bit of self-selection bias going on there. I'm going to have to do another bit of research. At least half of these papers are not empirical papers. It was kind of annoying to sort through all of them and find out what. We kept reading papers that were theoretical economic papers with even loosely defining empirical as having some data, right? Even a small bit of data, 50% of them don't. So this may be a bit misleading and overly promoting the empirical wave. If we just look at copyright, at the Copyright Evidence Wiki, you see similar growth, just 1 from 1993, 16 from 2003, 57 from 2013. Oddly, if you jump 10 more years, it drops to 14. This, I think, is evidence of one thing I wanted to point out in empirical studies. You're only as good as your database, and maybe things haven't been categorized in that year. I doubt that there's been a loss of interest in empirical legal studies and copyright over this time, but we always want to have our antenna up for counterintuitive things we find in databases, and that's part of this presentation, I hope, is maybe to sharpen our instincts when we think about empirical projects that other people are working on. So just briefly, why this growth in empirical legal studies? Part of it is driven by regulators, especially in the UK, God love them, who actually want to do evidence-based decision making and who ask for, and as you know, regularly provides empirical work to the UK IPO. And this provides a really nice balance to sort of special interest lobbying that's not based on empirical research. It's one way that heavily funded industries can be balanced and not, as they do in the United States, have complete charge over most legislative initiatives. For me, coming from originally a more theoretical economic background, I think it's we come to the point where we have enough economic theories about intellectual property. There's dozens and dozens of papers, and it's time to test them. It's time to see whether laws in their operation are consistent with the theories behind them. Right? If the legislature passes an IP law thinking X will happen, well, let's test and see whether X has happened. All of this provides nice incentives to do empirical work. So what I want to do today is, like I said, pull these examples from all different kinds of IP law: patents, copyrights, trademarks, trade secrets, and design research. Hopefully we'll get to at least 5 papers with 5 different subject matters. And I've also tried to find papers that exhibit different kinds of methodologies. So we've got quasi-natural experiments with heavy statistical work. We have AI and large language model papers. We've got a human subjects experiment. We've got a case study, or is it really a case study? And sort of everything but surveys, which are the easiest to understand. And I have one you could link to, this 2024 UK Visual Artist Survey. You can see just sort of descriptive data about earnings. That's easiest to understand, and I didn't find one actually in the database. So I'll just flag that for now. I've provided links. I'm happy to share my slides so you can have links to any of these papers. So what's the goal for today? Again, just sort of get a sense of what's going on out there over the last year. Getting increasing familiarity with available methodologies that we all might use. And I have to say that I have no special training. The empirical work, it needs to be done carefully. It needs to be done with reference to experts. For example, I hire a PhD in statistics to crunch my numbers because I don't trust myself, right? But empirical work can be done with care by, I think, any reasonable and sort of sharp-eyed academic. Okay, we read a lot of empirical papers. Whether we do the work or not, you can't avoid them. So sharpening your critical perspective, or our critical perspective, and testing our intuition when we look at a thesis that looks kind of crazy, I think is worth doing, and hopefully we'll do a little bit of that today. And though that critical perspective can be trained on the sort of research design of the project, it could be a great research design, but the claims might be inflated. Maybe everything is done perfectly, but the causal claims are inappropriately broad. What we're not going to do, and you're welcome, we're not going to talk about the accuracy of any of the statistical work at all. I assume in all my critiques that they've done a great job on their stats, and actually it does look that way to me. Finally, some of this stuff is intrinsically interesting. Some of these papers really raise interesting questions and answer interesting questions, whether you're an IP scholar or an empiricist or not. And like I said, it might be best I could take a couple questions after each paper just to maybe make it easier for me and for you to swallow some of this material. So the first paper, and this is a good one to start out with, is a trademark paper. And the research question that's addressed by the authors is, can an artificial intelligence be trained to predict when a proposed trademark is inherently distinctive? So just a brief bit of trademark law. What is an inherently distinctive trademark? So the kernel up there, Kentucky Fried Chicken, not an inherently distinctive trademark. Why? Because Kentucky Fried Chicken is very descriptive of what you get when you go to a Kentucky Fried Chicken outlet. Apple, though, for computers, right? Apple's don't have any connections to computers whatsoever. If there's no or almost no connection between the word and the product, then we say that the mark is inherently distinctive, that somehow it immediately and magically functions as a trademark. And we don't require the trademark owner to provide any proof that actual consumers perceive the words to indicate a unique source of the product. When Kentucky Fried Chicken applies to get a trademark, they have to prove, they have to have consumer surveys and advertising to show that this isn't sort of a generic descriptive term that we associate with a particular chain of restaurants. So this is something the USPTO, the United States Patent and Trademark Office, does, makes these inherent distinctiveness determinations because it bears on how registrable a mark is, and of course it's relevant in litigation too. So what the authors did here is they scraped 1.5 million US trademark registrations over a 7-year period. And then there's sort of related documents that come with each registration to correspondence with the trademark office. All of this is scraped and put into a database. And the goal is, and also the result in the case, the result of the application is also contained in the database, or at least the authors have extracted the answer as to whether the USPTO found the mark to be inherently distinctive or not. I'm not going to go into why that's actually kind of hard to do, but they've done it in a convincing fashion. And each of the determinations is linked to information in the application, like the type of good it's applied to, the description of the good, the NICE international category of the good. So we've got a huge amount of scraped data, which they then feed into BERT. So BERT is the bidirectional encoder representations from transformers. That is a deep learning model developed by Google. Basically, Google, as you know, scraped as much text data as it can. And then what BERT has done is analyze statistically the relationship of words to each other, not just side by side, but scattered even more broadly over the database. So you can train BERT to do various tasks, and what the authors did was feed all of this data they scraped into BERT, and also give BERT the information as to whether the USPTO found a particular word to be inherently distinctive or not. And basically what BERT is going to do, which is what all AI models do, is create its own internal rules. It's got all the data, it knows what the USPTO has done. It's told basically, generate your own rules here. What seems to matter in these determinations? And then when we give you a word and a product category, you will predict what the USPTO will do. All AI are prediction engines. What will be found to be inherently distinctive in the next case? Now, what's really interesting and sort of a nice test of the model is BERT correctly predicts the actual USPTO result 86% of the time. After the model was built and the rules were generated, the authors then fed all of the words, all of the putative trademarks, back into the AI and said, okay, here, apply your rules, tell us which marks are inherently distinctive and which are not. Now, hopefully you're kind of scratching your heads, right? BERT correctly predicts the actual result. BERT knows the result, right? It knows the results in all these cases. Why is it only predicting correctly 86% of the inherent distinctiveness determinations? So, I mean, shouldn't it be right 100% of the time, since it actually has been told the answers to every single putative trademark that it's encountered? Well, that's not the way AI works, and you need to understand, this is the reason why I thought this was a good project to talk about. BERT is going to go by the rules that it developed. It may be that what BERT has done is discover that the USPTO is wrong 14% of the time. It may be that it's discovering the USPTO is inconsistent in its rules, because BERT's not inconsistent in its rules if it's been trained properly. So this is sort of independence AI models have. They generate their own rules, they then apply them, and they're not bound by the actual reality of what the USPTO held in a particular case. So a very interesting bit of research. Have they reverse engineered the real error rate at the USPTO? They don't claim this, right? Stefan Bechtold is one of the authors. He never overclaims, right? That's one of his great selling points. They don't claim to have discovered the magic bullet that the USPTO should always use. They don't argue, we've created this for the USPTO. They should just use our model to now provide answers. They're much more modest, right? The claim is that their platform can help lawyers think about whether a trademark is inherently distinctive or not. Should help trademark decision making in firms. If a firm wants to choose an inherently distinctive word, then this model should be able to help answer the question whether it is or not. Could help trademark offices like the USPTO. They don't have to feel bound, but as an initial cut, they might be interested in the answer that the platform would provide. Should this help judges? This is an interesting question, whether this would be admissible in evidence. Would the result of the predicted by the AI model be admissible into evidence? I'm not an evidence person. I don't know whether this will ever be used to help judges. But it's much more modest claims than you might think. And there's something very nice about the way BERT works, is it reports confidence levels. So it not only will tell you whether a word should be found to be inherent, or will predict a word will be found to be inherently distinctiveness, it will tell you how confident it is that the USPTO will do that. So it really can identify tough calls. When there's a low confidence level, BERT's saying, we need human intervention here to think harder about this particular question. So yeah, this is, AI actually can be useful for things other than keeping you up at night talking about your love life to Gemini. You wouldn't do that. I'm not, because of time, I'm not going to have a minor quibble, and I don't think I should spend the time on that quibble. Now, I want to talk about my failed research project here for just a second, because it'll only take a couple minutes, and it shows what can happen sometimes with empirical projects. It's also an AI project too, and it's a different kind of AI project. And just to stay on the cutting edge, I think it's worth spending 2 or 3 minutes on. So my research question, what I'm still interested in, is does EU design protection incentivize more diversity in consumer products than US law? Because the EU law is really strong. You invent a new toaster, you get strong protection. You invent a new toaster in the US, people can knock it off and get away with it very, 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 very easily. And the question, well, was what regime is better? What gets you more and better, I shouldn't say better, what gets you more, a greater variety of toasters? So we scraped all images of toasters and a whole bunch of other stuff, a whole bunch of other products from Amazon.com, German, France, and UK versions of Amazon. And the AI comes in at the comparison stage. We use this CLIP AI comparison platform to compare all the toasters in the US to each other. So it's about 300 toasters. We compare each to each other, so that's thousands of image comparisons. And the CLIP will generate what's basically a diversity score. How different, and I'll show you how this works on the next page, how different are American toasters to each other. And then we did the same thing with German, French, and UK toasters. Like I said, you have to know where your weaknesses are. I have a brilliant computer science graduate student who's doing this, not me. And he set all of this up. And my role, his role was to sort of tell CLIP what are the parameters, what are the data labels to look at when these images are being compared. Color, shape, orientation, shading. There's a number of parameters that are relevant when you're comparing images. So he sets that up. My role was to observe the results and identify those that I thought were too alike in the sense that there would be a misappropriation case, or there would be a strong argument that the second image was a misappropriation of the first image under US or EU law. Thankfully, the misappropriation, the infringement rules are about the same in the EU and the US. So we would just go back and forth. He would let Clip do an initial ranking of the most alike toasters, and then I'd go through them and go down and say, hey, these are too much alike. And we iterate it in this higher level training capacity that I have. So eventually, you end up with something like this. The most, as you can tell, all these on the left, they're basically the same toaster. If they're made by different companies, then you have clear example of misappropriation. At the top, I actually would have flagged that and said, no, that's too much alike, and the next iteration of the results would have placed it farther towards the bottom. That's alike, that's alike. What about this? And then you start getting to close calls. Probably not too much alike. Is this too much alike? The point isn't to to perfectly identify what you're too much alike, because we're not developing an infringement prediction mechanism. But you can see that eventually, after enough iterations, it was pretty awesome. You'd have 20 toasters that were exactly the same, a couple of toasters that looked somewhat alike, and then a bunch of toasters that didn't look like each other. Did a really good job of sort of sorting tosterness, if you want to look at it that way. All right, that's pretty promising, right? And you get, how did it do that? I made it not do that. Okay. And you get these diversity scores. So the lower the score, the less diversity. So there were some sort of promising initial results in that the US toasters get the lowest diversity score. When we did razors, US got the lowest diversity score with lamps, almost the lowest diversity score. These are really statistically significant because it's a result of thousands of comparisons, right? Doesn't look like huge differences, but they are. Sounds promising, right? US law, a lot of misappropriation, not much protection, so you don't get as many different kinds of toasters. Look at the French, man. They love crazy different kinds of toasters. The EU law is really working great. And then I gave this at a conference, these preliminary results, and they asked the killer question, which has to do with a huge question that arises in most empirical work, and that is, okay, you may have shown a correlation, you may have done some interesting stats work, it may be significant, but have you said anything about causation at all? And in this context, it's a deadly question, right? Because the question was, maybe you've said something about supply. You've told us quite a bit about the supply of toasters. What if this is all driven by demand? What if French people demand more different kinds of toasters, right? What if all of the diversity is driven by the demand of French consumers or German consumers and not by the law at all? And I don't have an answer for that. I keep asking people for help, and I don't think there's an answer. I can't figure out a way to do anything more than show correlation because the causation question is, I think, a pretty good one. I don't know how to sort out French taste and preferences from European design law. So, good try, but that's what tenure's all about. I can do stuff like this, and it doesn't matter. All right, now a terrible paper, yeah. Oh, that's right. I was going to ask questions.
You to your promise before. Do you want to pause here?
Yeah.
It's so interesting.
Yeah. So either toasters, either toasters or trademarks. Either one. Yeah. I'm sorry.
So two things. One is it's unfair, I think, to critique someone's paper that aren't here in the room from my perspective. But
that's.
But the
clearly wrong.
one of the reasons why I think we've struggled, and I've definitely struggled with designing research projects that use AI in a way like similarly to how Bechtold and Beebe have done theirs, is the question of, well, what are you actually testing? What are you actually observing, right? Are you observing the trademark, patent and trademark office and their behavior over history? Or are you observing the ability of a slightly out-of-date machine learning model that was widely used in academia to predict some text that you've given it. You know, like, is this a computer science project? Is this a real socio-legal project? Like, because if we used a different model with maybe better predictive abilities, we get a different result, right? I'm sure Ziha's nodding, right? So then it's a question of, oh, well, great, hey, you know, thank you, computer scientists. You built a better model that more accurately predicts from historical data what the USPTO would do. But I mean, in terms of like its practical, you know, value, I mean, you know, and I'm sure you've probably hit on this. It's like, well, would you advise the USPTO to change their behavior because the model predicted something? I mean, that's a historical corpus of decisions that reflect the changing social and cultural beliefs of that moment. Right? It's always backwards looking. So I think it's of limited use for future prediction or future you know, behavioral change. In terms of your paper, what I really like is when you use AI not sort of as the object of study, but like to solve a data collection problem, which I think you know you've done really well. And so I would here all I would suggest is, I mean, you know, obviously the causation thing is difficult, but you could help by bringing in some controls. So you could do the same analysis on product categories where you don't expect to see, you know, the effect of the you know, design right, and then at least that would give you some authority to say, well, look, I've tried to eliminate missing variables, like the French's proclivity for unusualness. Right? So you could eliminate some of that with just some better controls.
Yeah, okay. Now, I think I'll have to think about that, but yeah, there may be products where we wouldn't. Yeah, okay. That's I'll take that on board, and we can talk about it later. The first question gets me to my quibble, because I had the same sort of thoughts with their paper, and then I've communicated with them at length. So there's no such thing as the problem is there's no such thing as an inherently distinctive trademark. It's a legal fiction, right? A trademark is a symbol that is recognized by consumers as an indicator of a single source of a product. And until the mark is actually used in commerce and consumers actually see it, it's not a trademark. But legally, it's not a trademark. So the notion that a trademark can be protectable from the moment the application is submitted before consumers have ever seen it it's not insane. It's just a legal fiction. The reason why we do it is because the cost of making a mistake is really low. Because if there's no connection between the trademark and the underlying product, it has no descriptive qualities. If we screw up, the public doesn't pay any price. If we make a mistake and give a computer company Apple as their trademark, who cares? Somebody else can use a pear or a grape or a turtle, you know. So it saves judicial. The reason why we have the doctrine is to save judicial resources in a context where the error costs are really, really low. So the deep trademark thinkers in this context would want an effect on competition test. So what the AI would do is tell us which words actually have value in the market, which words, if we gave a legal right to them, would give a competitive advantage, or at least an advantage in describing the product. So we'd look to the actual reason why we have, the actual concern we have underlying trademark law. And there are actually ways, if there's a competition law person, there's actually some sort of interesting competition law methodologies that one could use to actually predict whether giving firm A word X as its property would have discernible or significant negative effects in the market. So I'm with you, and they actually think that's a good idea. Whether they're going to follow up or not, I don't know.
Question also on Mark's paper. Just some additional perspective on from this side of the pond. We have here a registration-based trademark system. Right? So we also see legal presumption in inherent distinctiveness as also incentives to business expansion, because one can plan their marketing expansion in investment in the brand before beginning to using it. Whereas common belief is that on a use-based system, anyone could actually step in and begin using the market before you, regardless of any investment you have made. So this is the European narrative. But what I was more interested in is that when I was looking into the, I think it was 16%, which was kind of the other number, or 14.
Yeah.
I wonder whether actually this may have to do with things such as failure to function doctrine in US trademark law. So one of the things that, correct me if I'm wrong, I'm not a utmost US trademark law specialist, but as far as I know, one of the ways to deal with the problem of inherently distinctive trademarks, which should not be granted, is essentially the failure to function doctrine, which is essentially a way for the USPTO to say, hang on a minute, I'm not so easily accept that this is actually distinctive. So I'm going to say that it's not functioning as a trademark, so it's up to you to actually rebut this presumption now and submit some evidence. So from the inheritance student side, I can see how it can easily be coded if you just use the rules of thumb that we have, like relationship with the products and services. Yes, suggested trademarks a bit of a gray area, but then what about these even more unpredictable things such as failure to function? So is the paper accounting for these kind of doctrines? And if so, can we possibly train enough an AI model so it can also predict that? Because I think that would be actually the leap when it comes to AI.
Yeah, they have a really, and that's what I didn't want to get into, but they have a really, I think, clever but very labor-intensive way of dealing with that. And there's a couple of other similar sort of doctrines they have to deal with.
Oh, sorry, they're actually accounting for
Yeah. It's really carefully done, but because the trademark office doesn't declare. Right, your mark is inherently distinctive. It's buried in the correspondence. Yeah, exactly. All right, so let's go to, and I disagree that it's unfair to. I mean, it would be like you couldn't critique any dead scholar then, right? I mean, we can't have that. That can't be true.
From my perspective.
Okay, well, we'll see if you feel the same way after this. So the research question here is, does the rejection of the inevitable disclosure doctrine affect firm decisions to make R&D expenditures? All right, what's the inevitable disclosure doctrine? It's a very fringe, rarely invoked doctrine that lets courts enjoin a new employee from employment, even with no non-compete. It's the only doctrine where you can get an injunction against a new employee starting work in the absence of a written non-compete. But we do this on the theory that some employees will inevitably disclose a trade secret. If they take a new job, they can't help but disclose it. They already have the knowledge, and it will be inevitable that they use, even if they're good people, even if they're good people and they don't try, and they try very hard not to disclose, they will use it naturally. So you can see this is not a crazy theory, but you can see that it's not, possibly the most important theory in trade secret law that you've ever heard of before. And I don't know if there's a European equivalent of this or not. So it's this doctrine that prevents the really non-conscious disclosure of trade secrets learned on a prior job. Okay, all right, that's fine. It is a doctrine. If a court rejects the doctrine, it does make it slightly harder to protect trade secrets, right? If a court rejects the doctrine, you can see it's slightly harder to protect trade secrets. Okay, that's not crazy. Two things that kind of initially sow doubts is, one, you can get a written non-compete. So if you're a firm and you're worried about this issue, you're going to get a written non-compete. You're never going to rely on the inevitable disclosure doctrine to protect you. That would be really dumb. It's controversial. It involves litigations. You're just going to get a non-compete. So it should hardly ever be relevant in real life. More importantly, there's a really interesting literature that suggests weak enforcement of non-competes increases research and development and innovation due to information spillovers. What does this mean? It was a comparison of Massachusetts, which loves non-competes, and California that hates non-competes. And basically they found that there's more R&D. It's hard to control for, but that there'd be more R&D in the similarly situated California firms than in the Massachusetts firms, probably because there's employees going from firm to firm all the time sharing their knowledge. Okay. I'm not saying that those studies are always 100% correct, but you gotta at least acknowledge them in your paper if you're going to make the claims that we're going to see in this particular paper. Methodology is actually not bad at all. They've identified through this National Science Foundation survey of a whole lot of American firms self-identify as either thinking trade secret law is important or not important. So they categorize certain firms as trade secret dependent who self-identify as thinking trade secret law is important. They do have direct evidence of R&D expenditures. This is self-reported in the same survey. And what they're doing is sort of a difference in difference methodology using primarily Poisson regressions, which we're not going to get into. But they're looking at jurisdictions where the law changed, and they have data before a court rejects the inevitable disclosure doctrine, and then R&D data from after in these same jurisdictions the court has rejected the inevitable disclosure doctrine. Okay. So we're trying to see whether rejection of the doctrine diminishes R&D expenditures, because trade secrets, at least in theory, become less protectable. It's therefore a quasi-natural experiment. We're going to look, or they look at the judicial rejection of IDD and then measure research and development in trade secret dependent firms before and after the decision. It's a highly sensible thing. They got two really nice control groups. We won't spend too much time on this, but they have one control group of non-trade secret dependent firms in the same state. So these are firms that don't care about trade secrets in the same state. We're going to see whether during this relevant time period something else might have been going on in the state that changed general R&D proclivities. So that's a nice way to control for the possibility that there's something other than the judicial decision which is driving any change in R&D. And then they look outside the state at trade secret dependent firms, right? Is there something happening nationally that's affecting the behavior, the R&D behavior of trade secret dependent firms? So this is, I really like this. This is very, very good way to control for the possibility that something other than the judicial decision is driving any sort of changes that they find. Now here's though where we start to have problems, not in the stats work and really not in this part of the research design, but the authors are only able to find two jurisdictions that they identify where they identify the Supreme Court, the state Supreme Court, as rejecting the inevitable disclosure doctrine. So all the data is from just Georgia and Massachusetts. It's not nationwide. And unfortunately, it's completely unclear whether the law changed at all in those states. Okay, so if there's no change in the law in Georgia and Massachusetts, then any change in R&D over time that you find is clearly not being driven by change in law, because there is no change in law. They also don't tell us how many observations they have in each jurisdiction. They don't tell us what percent firms are trade secret defendant. So I did some research. A lot of these papers sent me to do my own research to see what's going on. So this is a quote from U.S. law firms. Well, U.K. law firms do too. A lot of good information. So this was a law firm that's done a bunch of research on the inevitable disclosure doctrine. 17 states have accepted it. 5 states have rejected it. The other 28 haven't decided. Notice that Georgia and Massachusetts are not on the list. And this was then cited by a federal court accepting this data as being informative. And I went and actually looked at the Georgia and Massachusetts. I don't think either of these states actually changed their law at all, which is a problem, especially when you look at the findings. So the treated firms, these are the trade secret dependent firms before and after the alleged Supreme Court change in the law, 57% reduction in R&D expenditures, simply because, and these are causal claims. They're not being modest like our previous paper. It's like these firms decrease their R&D expenditures 57% because of the state Supreme Court rejection of the inevitable disclosure doctrine. Reduction in patent applications by 70%. I mean, there's almost no commercial events that rock an entire industry like this. And even reduction in sales of new products from the company. And these are all causal claims that the authors are making. And I think that the second one here might be really informed. Like, what's the connect? Why should the rejection of a trade secret doctrine reduce your patent filings? It should be the exact opposite, right? If suddenly your trade secrets are insecure, it's time to go to the patent office, right? It's time to go to the patent, and instead we see okay. So there you go. All I'm going to say is some papers are, I'll say this for Chris, some papers are more convincing than others. How's that for fair? How's that for fair? Okay. And I kind of figured out, because I'm like, how could this happen? So I went and actually found the survey. The only question about trade secrets in this survey is right here. How important to your company were the following types of intellectual property protection? Trade secrets, you mark very important, somewhat important, or not important. You could do a nice robustness check. After the supposed change in the law, you might see whether whether firms move from very to somewhat important or somewhat to not important. Most importantly, want to know who filled out the form. I've done these kind of surveys before. They go to the business, and like the summer intern fills out these forms. I'd like to, yeah. So that may be the source of some of the weirdness, but anyway, that's. It's always worth doing when you run into something that instinctively seems wrong. Sometimes you have to really dig and try to figure out what's going on. Sometimes you find out something counterintuitive is correct. Can be a very, very powerful experience, but not one that I had there. All right, we've got plenty of time. Good. Oh, questions about that? Questions about that? I should say, the trade secret paper. Anybody want to rush to the defense? It's just, and the one thing I did find which shocked the heck out of me, because there was a string cite in the paper. These people are not lawyers; they're finance professors, and there is a cottage industry around the inevitable disclosure doctrine for some reason, and they were able to cite like 15 papers, all of which find massive effects in local economies from rejection of the inevitable disclosure doctrine, and so yeah. All right. Yeah.
I mean, this might go into too much detail. Do you have any information on the funding of the academics?
Oh, you're really, really mean.
I'm asking.
See, not only I say it's a bad paper, she says it's corrupt. I mean, this is even worse. This is even worse.
We all need money, and if the government doesn't give us money, but
yeah. So all yeah.
The Federal Trade Commission says doesn't matter. It's not relevant to competition.
Yeah. So I don't have any information on funding. I do know that there is an extremely conservative part of academia that loves non-competes and loves restricting employment. So they may be part of that group. And all I say is look at if you want to go, look at the institutional affiliations of the authors, and that might provide a further hint. Okay, so back to trademark law. I like doing trademark law because it's kind of more accessible than patent law, even trade secret law. This is a human subjects experiment. Often, I mean, I've done them. They're really hard to do well. They're really hard to, I think, often get the kind of data that you'd like to publish. But this is, I think, a really interesting attempt to study the following research question, which I think is relevant in all of our jurisdictions. The generally accepted wisdom is a disclaimer cannot effectively dispel consumer confusion. So here we have the famous Chewy Vuitton dog toy, all right? And held to be an infringement of copyright. What if you have a really nice disclaimer, not associated with Louis Vuitton? If you dispel consumer confusion, does that make the appropriation of the trademark okay or not? Under US law, it's much easier to make that argument than it is under EU law. And it's generally accepted wisdom, easy to find cites and cites saying disclaimers don't work. Disclaimers don't work. Don't buy. Judges say, I won't accept a disclaimer. We all know disclaimers don't work. So they want to look a little harder at the question, because the disclaimers don't work research is really flawed, and it's really quite old at this point. So what they have is a methodology which is very clever. They pretend to be a firm selling T-shirts with an American sports team logo on it. So this is a throwback 1959 Notre Dame T-shirt being sold purportedly by this firm. What do they call themselves? Nostalgia Fabrics or something like that. And they have their subjects look at three different things. This is just the kind of ad you might see on eBay, for example. This is a little bit different in that there's a disclaimer underneath. It says, you can't read it, it says nostalgia brands not affiliated with or sponsored by the University of Notre Dame. And then they have the hardcore disclaimer, you don't get to buy the t-shirt unless you type the following in the box. I understand that this t-shirt is not put out by, affiliated, or connected with, or approved, or sponsored by the University of Notre Dame, okay? So three different groups of subjects looking at three different types of disclaimers. Not surprisingly, and I had animations that made this go one at a time, whatever. In the no disclaimer group, so this first one here, 70% are confused. 70% think this t-shirt comes from Notre Dame, okay? And unfortunately, that's the American mindset. In the disclaimer only group, so with the circle there, that reduced the confusion a good bit, reduced to 31%. There's plenty of American case law saying that's too much confusion. That would still be trademark infringement. But for the people who read the disclaimer and had to type it in, the level of confusion drops to 9%. Now, I kind of worry about those 9% of the people, right? I'm not sure we want them going to law school, but 9%. Now, that's well below the level of confusion that's actionable in the United States. All right, so this creates a situation where this market, in fact, could, in theory, develop in the United States if one is careful enough. Super interesting, right? You don't have to force people to type. If it's just a click box, right? If instead of forcing the people to type it in, it's just you just click underneath, I understand that this t-shirt, that only raises the level of confusion from 9 to 11%, which is still below. So it looks like a pretty workable disclaimer might work in the United States to dispel confusion and create a market for this sort of product. Now, it's not going to work in the EU, and my question is whether it might work in the UK, because the case that went to the EU came from the UK, which held that a disclaimer was fine in the famous Arsenal clothing case. We had a UK court saying, look, you can sell Arsenal scarves as long as it's crystal clear that you're not associated with Arsenal. Right? You're not ripping Arsenal off because you're not confusing a single consumer. They want to buy the cheaper scarf. They don't want to buy the full price Arsenal scarf. And as long as you're not tricking them at common law, that's okay. And that's true in the US. That's true under UK common law also. It goes up to the European Court of Justice, which says, sorry, UK, you didn't read the trademark directive well enough. We have this free riding doctrine that isn't based on consumer confusion. And you can't let this person sell Arsenal gear without the permission of Arsenal. And this is the price UK consumers pay, right? Here's your authentic Emirates jersey for 2024. It's going to cost you 110 pounds. You can go on the dark web. You don't even have to go on the dark web. You can go on the gray web and get the same shirt essentially for 17 pounds. So it's worth thinking about this, because if we can find a way to allow disclaimers to create competition in this kind of market, it has serious public welfare effects. All right, questions about this? I think this is really hard to do, but I'm pretty convinced by this.
I'm just wondering, so do you think if they can copy-paste the disclaimer in the typing set, or just there are...
Oh, good question. They had to type. They actually had to physically type. Mm-hmm.
Or there are some computer scientists who disable the JavaScript, and then probably
it's possible.
9%.
Yeah, maybe that's 9%. Right.
So how did they? So they built an actual website and asked people to do this. How did they then survey the confusion? So you're saying they tested confusion and you saw the percentages go down. How did they test the confusion? If they build like a real life scenario?
Okay, yeah. So what they did, it was a typical human subject experiment with, oh no, they didn't. They went on the Amazon Mechanical Turk.
Okay.
They did it on the Turk. Yep.
And so people actually were representing real consumers, and then those real consumers were tested for their confusion later.
Yeah, I don't remember how they filtered out the Turkers.
Okay.
I don't remember. And in this context, at least my university would have forced me to tell the Turkers this is not a real website. And in this context, does that pollute the results somehow? Turkers tend to be slightly more libertarian. They might be. You'd want to ask some sort of filtering questions at the beginning to make sure you're filtering out the anarcho, there should be no property rights people who could read through this, you know. But I'm actually pretty confident they did that. It's not too hard to do. Any other questions? All right. Now we can get to copyright. I wanted at least to get this far because there's another copyright. This is quite quick. And Christelia is a friend of Create, and she's come over here and done some really interesting work. And I'm not going to criticize the paper at all, except her choice to put it in this particular database of empirical papers, because what she's interested in is non-enforcement of copyrights. Who doesn't enforce their copyrights? What are patterns of non-enforcement? And this is something I've looked at too. And she creates a really nice, super useful taxonomy of when copyright owners don't enforce their copyrights. But it's not a study of a particular universe of creators or copyright holders. She just uses very brief factual examples to illustrate each category she's created. So it's a theoretical taxonomy that's then illustrated very nicely and accurately by cases she's found or actions are taken or not taken by copyright owners. So that's, again, that's hardly a quibble. Two findings, one of which I think is worth pursuing just a moment for the purposes of thinking about future empirical work. Finding number one is not all private enforcement decisions serve only the conventional purposes of compensation, deterrence, or efficiency. You can think of copyright owners who sue for reasons other than money because they're just upset Donald Trump is using their song in the background of one of his rallies, right? There are moral rights sorts of justifications drive these decisions in the U.S. And that's important because we have very little protection of moral rights. So it's interesting to see that copyright owners using copyright to the same ends that in the EU you would use a moral rights argument. This is what I find most important or most interesting suggestion. Selective enforcement results in the public production of private information that lawmakers can use to improve the relevant law when the harm is tolerated. So these are the situations I find most interesting, and she does too. When do copyright owners tolerate infringements that they could easily take down, that they could easily enjoin, that they might easily be able to collect money from? So I thought there's several examples we can use. One of which is, like my favorite singer of all time, Jacques Brel. If you look on YouTube, there's all sorts of old Jacques Brel music up on YouTube, and it's not uploaded by the copyright owner. It's uploaded by individuals, and I did a much larger study of number one songs from 1960 to 2010 in Brazil, France, and the U.S. How they appear on YouTube. 98% were uploaded without the permission of the copyright owner, and yet there they are. They're there for everybody to view. They could be taken down in a heartbeat. With Content ID, super easy. You can you can automate your software to get these things taken down instantly, but they don't. So, I think part of the story is we know who owns the copyrights in the Brel compositions. My guess is they're thinking, hey, this, the more he's in the public eye, the more we're gonna make. I mean, this is, we're the victims of infringement here, but it may very well redound to our benefit by keeping one of our composers in the public eye. So we found enormous amounts on YouTube of tolerated infringement, and Christelia's suggestion is maybe, if we look at what's tolerated, we could do a better job of writing rules and regulations, because we wouldn't constantly be overreaching in the law and giving rights beyond what copyright owners seem to want to have. It's true in the parody context too. I did present a prior paper on porn parody. This was the least lascivious poster that I could find. Parody is tolerant. Even before, you had to tolerate parody in the UK, even before there was a UK parody exception, trademark owners and copyright owners would frequently tolerate parodies, and maybe that should inform our thinking about whether parody should be a protected category in the UK as it is, but it's not in every European jurisdiction. So that's sort of her point, is observing non-enforcement of copyright should and could inform regulatory decisions in the future. All right, questions about that? By Tannick, let me tell you, there's some great titles in this paper, but you missed it.
Actually, yeah.
Yeah.
Anybody else does about that? Because, so, I mean, and not to argue against our parody work, but just to play the devil's advocate here.
Are all of your co-authors here?
Yeah. Is the choice of the rights holder not to enforce sufficient for us to start digging into the law and making changes? Or would they maybe then be incentivized to enforce, to be careful that a bunch of academics don't uncover their ruse?
Yeah, I think it's more helpful looking forward and not undoing. I don't think there would be the momentum to undo and unproprietize existing copyrights. But if you're thinking, for example, of extending the length of copyright, or the length of performers' rights, or something like that, part of the consultation might cite something like this as, hey, these, why are we extending rights when they're not even being exercised? Yeah.
I might follow Chris' comment on that, because recently I'm doing the data analysis on Reddit posts. I find some very funny posts from the creators. They find someone on like ET, they mimic their design, they try to use the takedown system on ET, but unfortunately they find some the takedown notice they sent was due by the AI, so it's like automatically reject their appealing or reject their takedown request because the format doesn't satisfy the AI. The AI cannot do it, and it's rejected, and then some of the creators try to find the human to deal with their, and very frustrating. I find more than some, not like more than one, less than like around 7 or 8 creators found some platforms really use machine to deal with the takedown requests. That might reduce the their presume, like they try to protect their work. It's not their doing.
Yeah. So it might look like non-enforcement, but it's just, a failed attempt to enforce. That's why we stick with YouTube, because it's so automated and so easy to get things taken down. It really is. I've done it. Google too makes it extremely easy. Amazon makes it really, really easy. But there might be other.
The revenue share option, isn't it? So why should they forego that as a right holder?
Right. What we found with YouTube, and that was really interesting, we found a huge percentage were not monetized. Right. Which, it's like, why tolerate an infringement when you... And I think for something like this, the problem is that YouTube demands that all the rights holders make the request together. So it's not just the Brel estate, but whoever owns the copyright in the video. And that's super hard to track down. So that might explain some of it. But yeah, you're right. You can... You can automate the kind of monetize button too. Monetize if it's exactly the music that we submitted to you. Don't monetize if it's music in the background of somebody's slideshow, or it's pretty fine-grained what you can do. It's kind of a marvelous conversation between people who have access to old videos, for example, primarily, and old music, and those who own the copyrights, and it all sort of happens in an automated fashion and results in all sorts of stuff being on YouTube that you would think would not legally be there.
There's another factor which weighs in your favor, because the risks are so high for the channel owner.
Yeah.
Because there's 3 strikes and
Right.
you're out, and
Yeah.
your channel is deleted. So if you have invested time and effort into that, you really, really hate to have a copyright strike. So that would suggest that they are not being punished at least enough that it would actually endanger their investment.
Yeah, I think that's right. We also found really different enforcement for Brazil and France, and U.S. copyright owners behave really differently.
Sorry.
Yep. Yeah. Sorry.
I mean, I'm fascinated, I think, because I'm the token Belgian in the room, but for Jacques Brel, it would be, I think, a really good example to actually test this, because Edition Jacques Brel has its headquarters in Brussels, and I think their main aim, because I don't know how much you noticed, but Jacques Brel is the resistance singer of Belgian culture. So he's a cultural icon rather than a commercial icon. And that's, as far as I've understood, their main aim of the rights holders, to memorize Belgian resistance songs rather than commercial icons. So it would be a really cool example to test. So it's just a suggestion. They exist, they are there. It's his granddaughter, I think, that is running it. So you could
Just send me a link, because I won't remember the exact name, but send me a link.
But you could, you could test this.
Yeah.
That's cool.
Or one of my, and I don't want to steal ideas from the Create team here either. So we're supposed to, it's 4:30. Could you keep going? Stop me when this gets boring. So we have to get back to patent law here, which is the hardest to think about. But this is, or actually we haven't done patent. We've just talked about trade secrets. This is good. So I've got 2 patent things. Hopefully we won't get to the last one because it's kind of nasty. But this research question is really quite easy. We had some monumental, or at least very famous, Supreme Court cases on subject matter patentability in patents. The Alice case involved the patentability of basically a very it's essentially a very common financial move, but doing it online, doing it with the software instead. You see a lot of these cases in the U.S. Either way, famous case. And what the author's interested in is, well, after this big case, which changed the law to a certain extent, or at least clarified the law, you might expect to see a drop in investment in business method startups, right? Because Alice certainly made it harder to get a patent in your business method. There's no doubt about that. Harder to get a patent in your business method. And they're looking for regression discontinuities before and after Alice, right, to query whether patenting attracts investments in business method patents or not. So it's a pretty clean model where you're looking at investment in business method patents before and after Alice. Now, what you find out very quickly and comes as no surprise to anybody is that before Alice, there's a 45% grant rate on business method patents. So 45%, the patent office says, yes, you may have a patent, and that drops to 10% almost immediately. Okay, so there is absolutely a change in behavior in the patent office. It becomes more difficult to get a business method patent. Okay, that's might be the kind of change that has an effect on investment in business methods. The key finding, though, is that there's no change in the likelihood of funding or the amount of funding or the likelihood of acquisition of a firm that was active in the business method patenting market. Okay, all right, well, that's interesting. I think I can explain why that might be so. I'll note this is a null result. You're reporting a null result. I have friends who are psychologists who their hair catches on fire when any lawyer or economist reports a null result, right? You cannot go to a psych conference apparently and say, I didn't find anything. This is an interesting finding or this is an interesting non-finding, at least initially. Now, I think the question we want to ask is, what was the patent invalidity rate before and after Alice, right? We've talked about the grant rate, how likely it became less likely to get a patent after Alice. But what percent of patents, what percent of business method patents were enforced after Alice? In other words, we know that the application data changed, but once a patent was issued, was there any change in the validity rate? In other words, did it become more likely that courts would strike down business method patents? Did it become more likely that they would, or did it become more likely that the USPTO appeal board would invalidate a previously granted patent? So, in other words, things changed in the patent office. What if firms were already discounting? What if firms already understood that Alice was good law? Because the pre-Alice law was heavily criticized. And what we have here is sort of before and after Alice. This is just the absolute numbers of valid and enforced business method patents. So it goes from a little over 4,000, it drops to 37. We have Alice in 2014. It goes from a little more than 4,000 back to 37, then up to 39, then up to 42. We don't really see the sort of sea change in validity determinations that we would expect to drive investment in business method patents. Now, you're less likely as a statistical matter to get a business method patent. I mean, notice in 2014, there were 10,000 applications and only 4,000 held valid. So you can see where that drop in the grant rate happens. But in the absolute numbers of patents, business method patents granted, really are not particularly affected over the same period of time. So this backs up a lot of previous research that casts doubt on whether looking at grant rates and what happens with patent applications really tells us too much about what's going on in the real world. I think businesses, sophisticated businesses with decent attorneys, knew that Alice was coming 20 years before Alice actually happened, probably. So that's part of the explanation why I don't think there's much of a change here. Now, the reason why I wasn't surprised is because there's a previous paper by Holland Sedonis going back actually into the 90s, which is, I think, the best academic paper that the best empirical paper that's ever been written. And what the paper does is we had a big change in 1994 in the US. We took all of the patent cases out of the courts of appeal, created a new court of appeal for the federal circuit that's expert in patent cases. It's massive change, great opportunity for a natural experiment. What happens? The patent validity rate doubles and then triples within just 2 years. Patents become much more enforceable, much more enforceable within just 2 years after this change. And the patent applications actually track that. Patent applications double and then triples over this period of time. Okay. What happens to R&D expenditures over this period of time? They're absolutely flat. You have way more patenting activity. You have way more chance that your patent is going to be held valid. Patents become more valid, more enforceable. No effect on R&D expenditures. And they were the first, but it's kind of a cottage industry to show that there's really no tight connection between what is happening in the patent office and what happens in corporate boardrooms and their R&D expenditure decisions. So there's nothing wrong with this paper. I think everything is right. The stats are right. Research design is good. Everything about this paper is fine. It's just kind of meh. Okay, we've got this unsurprising null result. And the only criticism you can make is this kind of overselling. This gives me a chance to rail against U.S. law reviews, right? This paper is written for U.S. law reviews, which means only students are going to read it and only students are going to make the publication decision. So you have tremendous temptation to oversell your results and make this sound like this is the first time anybody's ever done something like this. It's a horrible problem with the U.S. System. Okay, questions about that? All right, well, maybe just one more, because this is copyright. One more quick copyright, and it's hip hop, so it's fun. I should have there should be like a soundtrack to part of the presentation. So there was a decision back in the 90s that essentially required hip-hop artists to get permission to use samples. Okay, that, you know, possibly could have changed the behavior of hip-hop artists. So the research question is, did the court decisions back in the 90s requiring permission to sample recordings affect the frequency and intensity of sampling in hip-hop? Which is good to know, because if there's a negative effect on creativity caused by a licensing permission requirement, then maybe we want to think about compulsory licensing or something like that. There is no compulsory licensing with sampling. Licensing means higher transaction costs, right? If you got to get a license, it not only do you have to pay, but you actually pay in terms of time and attorneys' fees. And because there's no compulsory licensing, each of the negotiations is contextual. So it's like getting a sync license. It's like if you're a movie director and you want to get permission to use a piece of music, there's no automated way to get those rights, at least in the US. You've got to negotiate. Same thing here. So higher cost, higher transaction, higher actual costs and higher transaction costs might lead to fewer samples in music. So totally rational, coherent intuition and something well worth testing, I think. So again, with the methodology, we've got a quasi-natural experiment. We're going to look at sampling in terms of frequency, how many songs on an album have a sample in them, and then intensity, how many samples per song, before and after the big case, which is Grand Upright Music versus Warner Brothers, 1991. All right, so I think the findings are actually kind of interesting, and copyright's a good place to end since this is Create. So the authors find that the decision led to a mean drop between 0.3 and 0.45 songs reused in each new hip-hop track. So this is the intensity question. Tracks are less likely to have samples or less likely to have more than one sample in them, because there's no drop in likelihood a song will contain a sample, right? So any particular song is just as likely to contain a sample, but overall, fewer songs are sampled because there's fewer songs that have 2 and 3 and 4 and 5 different samples in them. Okay, so that's sort of interesting. You're still, everybody's still sampling a lot in terms of frequency, but not quite so much in terms of intensity. I think this is probably an artifact of higher licensing fees. The more samples you put on your album, the more you got to pay, right? And you still want to sample, you're a hip-hop artist, you got to do it, but you're going to diminish your intensity because you need to save some money. That seems like an intuitive sort of result. But one may be that you kind of go, well, what's the policy takeaway here? Is there any sort of policy implications? You get to some policy implications because the authors look at what they call novel reuses. In other words, people sample themselves, right? So when you sample somebody else, that's a novel reuse, according to the authors. It's more creative. You're taking music from somebody else, incorporating it in your own. You're not just sampling yourself, something you already did. So songs were 9% less likely to include a novel reuse, which again also makes sense. You don't have to negotiate with yourself. You have to pay yourself a licensing fee. It's cheaper to sample yourself. So we do have a change in the novelness of reuses, somewhat more self-sampling. And here you might think about a negative effect on creativity, right? If novel reuses go down and you're more sampling of yourself, maybe, then there's no way to measure creativity, right? But at least it would be possible to argue that this might indicate that the songs are less creative than they might be otherwise. We have some nice robustness checks here. They also did the same test before and after the Bridgeport case, which is actually the more famous case. It's in my case book. But it's 2005, and they don't find any effect at all if you compare before Bridgeport and after Bridgeport. And I think that's because by then you had this really efficient, full-blown licensing regime. You know, there's only 5 or 6 really big record companies in the United States. They all tell each other, yeah, we'll just all sample each other, and at the end of the year we'll have a tote sheet and we'll see who owes who how much money. It becomes very efficient and to reduce those transaction costs in the US market. The authors look at cover songs as a robustness check. Was there any change in the amount of cover music over this same period of time? And there's not. So it's just suggests that there isn't some sort of unobserved sea change in the music industry happening at this time. And I think we already talked about this, but it's a quasi-robustness check. They find a decline in self-samples post-1991 was much lower than the decline in general sampling. I guess that's sort of intuitive given their first finding. But thinking about it as a check of robustness of the data analysis, it is suggestive that there is something going on here that's related to the court decision. And there's Moby. I thought Moby was back there for a second, but I thought he might be coming to my talk, but he did. I guess he declined. Okay, all right. Let's stop there because the last paper is really in the weeds patent stuff, and we probably don't need that. And we only have 10 minutes for questions about this or questions about anything at all, or off to drinks.
About sampling something yourself, wouldn't that be a motivator? aka, if you have to pay for sampling, the artist, and let's face it, the copyright is mostly with the production companies, so wouldn't it be a motivator for them to sample themselves so some royalties go to them? Like, no, or do they?
I would write a contract where that couldn't happen, but right, but
you know, in theory, that could be one of the off motivations. I will sample myself,
Sure,
so I will get some royalties into my own pocket.
I think that absolutely is possible, but boy, it would be bad lawyering on the part of the record company to let that happen, or maybe not. Yeah, and it'd be bad motivations too. If I'm for the record company, you've got to. I'll ask Cristelia though. She was, who we talked about earlier. She was a vice president at Sony, so she actually would know the answer to that question. I'll ask her, or you ask her when she comes next time. But yeah. Anything else? Do we need to hit the wine?
Well, I wonder, from this whole journey, so do you have any kind of big messages? When you looked at 1 year, different types, mostly US work.
That's my takeaway. No, I guess I'm just being evangelical about empirical work in the sense that it's clear sometimes, it's super valuable, just intrinsically and also for policy purposes. It's also clear that not every paper is equally convincing. But I'm mostly evangelical in that how many of us here have PhDs in stats? Probably nobody. How many of us have had more than one course on research design? Probably very few of us. You can do all of these things. You really can. It's just, be careful, be rational, know what your priors are. And I just am sort of a preacher on, encouraging people to do this stuff. And, if it doesn't work out, don't publish it. Just put it in the bin and move on to the next thing. But this is an audience where I don't really need to sell. I don't think I need to sell this very hard to this particular audience. I didn't know who was going to be here. It's in a med building. I thought there'd be doctors and stuff. All right. Okay. Thanks.
This is a natural conclusion. So I think we should, clap.
We should clap.